All right, welcome everybody to Legal Tech Week for March 22nd, 2024, which I found out earlier today is National Goof Off Day, and we are not going to be goofing off here at all because we have serious things to talk about. But this is the show where we talk about the top stories in legal tech and innovation from the past week. I'm Bob Ambrogi. I have a blog, Law Sites, and a podcast called Law Next. And our panelists today, Nikki, you want to kick it off?
Sure. My name is Niki Black. I am the head of SME and external education at My Case and Law Pay. I write legal tech columns for Above the Law, ABA Journal, and the Daily Record. And I also oversee and write some of the benchmark and industry reports that we put out on the My Case and Law Pay side of things. And I am looking forward to talking about conspiracy theories today, which I don't think is what we're actually talking about, but I'll work it in.
Talking about conspiracy?
Everything is a conspiracy theory if you try hard enough.
I guess. All right. Well, Stephanie, how about what's your conspiracy theory?
There is some conspiracy theory behind why I've been so sick all week. I don't know, because there's no other explanation. But I am Stephanie Wilkins. I'm the editor-in-chief of Legal Technology and Legal Tech News at ALM. And I am pulling myself out of whatever crud I've been in all week just for all of you to say hello.
Ish. Well, we hope you feel better quickly, at least by the end of the hour, maybe. And Jean.
I'm Jean O'Grady, and I write the Dewey B Strategic blog and a monthly column for Legal Tech Hub.
And last but not least, coming from the West Coast, Joe.
Joe Patrice from Above the Law and Thinking Like a Lawyer. Yes, I am in Fullerton, California for an event. It's good to, so I'm very tired, but it's good to be on this show. I was supposed to be on another show last night and I got bumped. So I'm glad I didn't get bumped from this one.
Are you going to show your office colleague or no?
Oh,
Yeah, show your office.
I've got to help her. Well, she's stopped paying attention there. Oh, no, now she sees she's back.
She's back.
Yeah. But
Still
she's
watching the basketball game.
Well, no, now she's trying to get her Winnie the Pooh picked up that she dropped. Oh well. Anywho, yeah, so we're here now.
All right. Well, some interesting stuff to talk about this week. But Stephanie, I hate to pick on you first because you're sick, but I thought the story you guys did this week was really kind of pretty notable in a lot of ways and kind of a wake-up call for a lot of people in the legal profession.
Yeah, there's a lot there. Yeah, the big story for Cassandra and Isha to team up. They're kind of a dream team there. But yeah, it's
I'll drop the link.
Everybody in legal loves Microsoft. So we all know by now well, or they pretend to, whatever. But so everybody, I mean, we all know by now, I hope, on this call, the risks of putting things straight into tools like Chat GPT, the confidentiality risks, the waiver of privilege risks, etc. And so when Microsoft rolled out its Azure OpenAI service, everyone thought, okay, this is the safer way to do it. We'll go through all this stuff. And then lo and behold, if you go through all these interlocking terms of service and terms of use, there's this abuse monitoring privilege in there that allows for certain, is not 100% clear, but imagine, certain language or whatever can trigger this provision, and it allows Microsoft employees to retain your prompts for 30 days and manually review them. Think of the certain kind of bad language that can review it, but that's exactly the kind of language that might be the subject of, say, a lawsuit. Things lawyers work with legitimately all the time, not as offensive language, but subjects of legal suits. And the only way to get around it is to get an exemption and get abuse monitoring turned off. And that's apparently a lot easier said than done. And also finding this provision is a lot easier said than done, even though people are lawyers making a lot of money to do exactly that. And it was just this huge wake-up call that a lot of people didn't know about. And some people have had it. There's companies I talked to in the article, Net Documents is one of the ones that went through the process of getting it. But yeah, apparently this was a wake-up call for a lot of people that have been doing this or using these tools for a long time and didn't know that, oh crap, we might be putting this stuff out there and we could be waiving privilege and breaking confidentiality to Microsoft, which I don't know. I mean, nobody, a lot of people, understandably, spoke on background and did not give their names. Not going to sell out their firms, not knowing that this was done. But it's, I mean, theoretically, a huge, huge issue.
Well, and the out for so many people in the legal profession who are using AI to say, "Oh, don't worry, we're using Azure for OpenAI, and
Exactly.
therefore none of this, none of these prompts are being transmitted anywhere." Unlike with OpenAI, where they are archiving your prompts for 30 days or whatever it is.
Well, and they,
And yeah,
yeah, and someone in the article says too, compared to Pat, and they've used Microsoft for so long with so many other tools that there was never data retention issues before either. So this is an about face with that too. So there was just this, I guess, illusion of security, and exactly, people waited for Microsoft. This will be the safe way to do it. We waited, now we're doing it, and now person used the term, cold shower. It's like sort of, oh, we waited, we thought we were doing it the safe way, and now, and it's sort of like, oh no, is this gonna, we finally got people on board and they thought they were doing it, and then now are we gonna have people backtracking again? And but it really is like a significant issue, because like I said, as much as Joe claims to love word perfect, Microsoft has this stranglehold on legal.
yeah. I mean, I was trying to think about it, uh, how much your prompts would ever actually reveal about a client confidence. I mean,
I think potentially a lot.
yeah,
Because
I,
I think it's
I don't think there's any question.
because it's easy to think of a prompt as like just a thing, but a prompt can be feeding in a whole document.
yeah,
Yeah.
true. That's true. I hadn't thought about
I
that.
mean, to tell you the truth, I used to worry about this back in the old days with just Lexis and Westlaw. I sometimes tried to have conversations with attorneys about this. Is like, do you worry that everyone at our firm is putting in so much information, asking about client? They do often include client names in searches to get background on things. I mean, there's so much that could have been exploited, and there always has been.
Well,
Yeah.
and also, if you are an attorney handling a high profile case, and there are people in my network, all of our networks that are doing that, they're handling like high profile litigation matters that are in the news. And if the company's aware that that's your case and you're doing queries that relate to strategy, even if you're not entering your client's case in there, but their case name or whatever it may be, you're still entering queries that are specific to the type of litigation. So that's not much of a jump to think that it's related to that case. So even that, I think, something that sort of far removed maybe could also be problematic. There's a lot of ways it could be, even if the query itself doesn't disclose confidential information.
Yeah.
And the different paths to getting this exemption from it is part of the problem too. So one of the ways to get this exemption is to become a managed partner or managed customer of Microsoft, and how you get that is unclear. Like some people were saying it estimated it took like they paid $300,000 or $500,000 to get that status. Another company was like, we just happened to know the right people and we called them a bunch and wrote an email and we somehow got through it. Or other people tried and couldn't get it. Or it's just like this mystery status to try to get.
But wait a minute, don't we own our own prompts? I mean, is there any issue of who owns the prompt? Couldn't
But
it be
not supposed to
considered
be
work
able.
product?
Well, they're not supposed to be able to review them, but if it triggers this abuse monitoring policy, they can retain them for 30 days and review them. That's the thing. That's that 30-day window where you're breaking the confidentiality or the privilege. And you can get abuse monitoring turned off. That's what people are trying to do. They're trying to get an exemption from this policy, get that turned off so they're not having that third-party review of their prompts.
Which NetDocuments did, as your article points
Yes.
out.
Yeah.
And, but a number, as I think CJ Webster pointed out in the chat, a number of the vendors are also saying they're using Azure for this, for the same reason, to protect the confidentiality of their customers who are using it. And I mean, Thomson Reuters has made a big deal about that. LexisNexis has made a big deal about the fact that they're using that. I wonder if they've all gotten this, if they've gotten this exemption that turns off the abuse monitoring. We don't know, but it'd be good to know. Also, a shout out to Casey Flaherty, right? That he was the one who kind of dug this up in the first place.
Yeah, he posted it on LinkedIn. He actually had sent the stuff to me. He's like, am I missing something here? And I walked through it and I was like, I can't see that you're missing anything. And then so he posted it on LinkedIn and I was like, interesting. So that's when Isha and Cassandra started digging through it more and talking to other people.
Yeah, yeah, that's really crazy. Um, that might be a good transition point, Nikki, to one of the stories that you highlighted this week on the question of sort of public versus private or commercial versus public control, not control, but development of AI.
Well, so I've been on a bit of a Schneier kick, because I think last week I also discussed one of his posts, but it's Schneier on security. It's from his blog, and it's a great idea. At the outset, I'm going to say I don't think that it's actually going to come to fruition, but what he's suggesting is that it would be to everyone's benefit if the AI development was almost treated like a utility, like gas and electric or something, where the government regulated it, or at least provided a neutral, not regulated, but provided a neutral AI tool that the government developed that had regulations built around it that controlled how it was developed, so that we would have AI tools that were not subject to corporate and big tech influences, and B, it sort of create a bar that would force the private companies to have to at least meet these minimum standards in order to compete. And I think that it's a wonderful concept. I can't imagine at this late stage capitalism era that we are living in that would come to fruition. I mean, I feel like these tech companies and corporations basically own Congress, and I may be a little cynical here, but I just can't see something like that coming to fruition. And like along the same lines, this is a little tertiary, but when I posted my roundup of legal news on LinkedIn, somebody posted Bernie Sanders' suggestion of a 4-day week. And like, that's a wonderful idea. That's never going to happen either. And this for the very same reason. So there's lots of great ideas out there and lots of altruistic concepts that people are coming up with, but I don't see that this is something that would come to fruition. But I thought it was important to highlight because I think that it is a pretty good solution to some of the issues that we have all pointed out that we see with AI development.
Schneier was at a program I went to at Harvard this summer on AI, and he was talking about this and about kind of just open source LLMs as an important consideration for like the judiciary or other aspects of government that are going to start actually using, generative AI in applications related to what they do. I mean, how the courts end up using this, we don't know yet. They haven't started using it that we know of. But he was putting forward that idea, and it was kind of well received by some of the judges who were at this conference that I was at. But how that you're right, how that develops, I don't know. And then there is the whole question of even if the government does get in the business of developing in some way large language models of its own, are they going to do any better in making that accessible to the public than they've done with case law, say, or other government materials where we're still fighting to get access to some of those things? So I don't know that necessarily, it necessarily follows that even if the government or some public body does get into the business of developing LLMs, whether it necessarily ensures all that much greater public access, but who knows?
Well, I
All
thought
right. Huh? What?
I thought it was interesting.
No, I think it's really interesting. I think it's an interesting thing, but apparently nobody else on the panel thinks it's interesting.
Well, I mean, I just always feel like this
I'm
is
sure
a
Joe's daughter is
historic.
very interested, but he's not letting us see her excitement over it.
She
Look at her.
is
She
staring.
is enthralled.
Yeah. Yeah. I actually think that this seems like it's been the story of technology forever, right? Like if you really engage in almost every major technological development, the government was at some point involved and actually did most of the heavy lifting, and then somehow it got sold off to somebody else to make profit off of it. So I absolutely think that we could do that. And what would happen if we went down the road of a public development is in 4 to 8 years, some administration change happens, and then it gets sold off to some bank, and that's just how that goes.
Yeah. Well, turning back to the commercial legal product development sector, Gene, you had a story this week about
Yeah,
Lex Machina.
a bit of a development from Lexis, which I thought was interesting for a few weeks. They released something called Litigation Footprint, which is in Lex Machina. And thankfully, they have left Lex Machina as a standalone platform because it really is a specialty product that wouldn't do well in a generic keyword search environment. But it's really clearly focused on, and I actually, now that when I was rereading my article, I began to wonder, they also own Interaction, which is their client development or client information database. And this Litigation Footprint creates these almost maps of where corporations and industries are in litigation, so you can compare it, federal litigation footprint to a state litigation footprint, and you can do it both by industry and by company. So because this is clearly, it's not so much a research tool as a marketing and business development tool on steroids, but I think they have done a pretty good job in terms of enhancing the information. Like they say, 10 bazillion entities, including courts, companies, people, they've all been data normalized. And that's really one of the powerful qualities that Lex Machina has had since it was developed. They have always done a really good job at normalizing their data. And now they have the ability to get into hierarchies of company relationships. And it was interesting when I talked to them, they wouldn't refer to it as a company tree because they're giving you access to every kind of affiliate. Say that, like if Apple has they don't actually own it, but they're in some kind of relationship with a company, you're going to be able to navigate down and find out who are all the entities that Apple has a relationship with. So, it really is a pretty powerful tool, especially for navigating to, a high level overview of who's doing the litigation in various states and who's representing those companies in various kinds of litigation in various states and and across the federal courts as well. So I thought it was an interesting new product, but I think if you married it with Interaction, and it would really be powerful for a firm to look at their own footprint compared to competitor firm footprint. So being a data geek, I thought it was interesting.
Yeah, I haven't seen it yet. I've got a demo coming up next week, so I haven't had a chance to see it. And I was wondering, does it have comparative? I mean, could I say, here are the states that Apple is active in, and here are the states that
Well,
Microsoft is
it'll
active
show
in,
you.
or
Yes, you can
yeah.
do that. Yeah, and it'll show you. I mean, that was the other interesting thing, is that all the mapping, so it's like these little boxes that line up and look like they basically roughly form into the shape of the United States, but they're all little boxes. And it's dynamic, so the color changes if you change your query and the number of the volume of litigation increases, the box gets darker. If you get more litigation in California, the California box will get deeper. So you can sort of interact with it and see how it changes depending on how you change your query. So
All right. How's your daughter's reaction to that story? How's she doing with that
she's asleep now.
one? Oh,
The
she's
basketball
left. She's tuned us
ba-
out. She's
Yeah.
basketball's taken over for her now. I guess there's
all
a
right.
comeback or something.
All right. All right.
But I just did want to say on a related, this Lex Machina is it's basically tied to dockets. I also noticed, and I wish I had put this as a recommended story, that Courthouse News is suing the court in DC because they don't immediately publish DC cases because they have to manually review everything. And I was thinking, wow, that would be a good application for AI to get the courts to get the DC. So I couldn't help but wonder, gee, could there be any politics at work in that? We have to hold all the opinions back. Can't publish
Yeah,
right away.
yeah, yeah. That's crazy. Uh, okay, Joe, where do you want to go to? Do you want to go presidential politics or taxing big law?
Let's do with the ridiculous presidential politics, which is, we shouldn't really even call it that because we're talking about RFK Jr. So the interesting angle for legal tech is that RFK Jr. is ostensibly running for president, and we had long thought he was going to take somebody as a running mate like Aaron Rodgers or some guy with a tinfoil hat on the street. But as it turns out, he's apparently in conversations with a former legal tech founder. So Nicole Shanahan's apparently one of his big donors, and there's some conversation that that's who will be the running mate when they make that announcement, I think next week. So we get to have our moment. Maybe there'll be a before he dissolves completely, we'll have a couple of puff stories about what does it mean to, what does this person do? What is legal tech? It's a moment for us all. We can we should be prepared.
Well, Nicole Shanahan is not a stranger to the spotlight in any sense. I mean, she was already had been married to the Google co-founder, was rumored to have been having an affair with none other than Elon Musk, eventually leading to the end of her marriage with the Google co-founder. And she was I had written about her a long time ago because one of my probably the greatest source of traffic for years to my website was writing about this guy Derek Bluford, who had been a legal tech founder, who up and coming promising guy, who was about to be a presenter at a legal week. What do they call it? Legal Tech New York, Legal Tech West Coast. They used to have a Legal Tech West Coast before it was just Legal Week in New York. He was going to be a presenter at a thing there, and she was going to be the judge of the thing he was going to be presenting at. And I wrote a story talking about how he had been engaged in fraudulently pretending to be a lawyer and taking money from clients and some other stuff that he was doing that wasn't so good. And about a week before that legal tech event, and they pulled him out. They canceled him out of the event. So, but
I feel like we're teetering into
Shanahan was,
TMZ territory here.
huh?
We're teetering into like gossip mag territory here. It's so funny.
Oh, totally.
It's a weird day.
No,
That's what's going to be great about it. We're going to be like all TMZ-ish with this VP thing.
Yeah. Yeah, we followed her to a nightclub last night, and we were there. Some of our photographers were on scene documenting the whole thing.
Wait, you followed her to a nightclub?
No, I'm kidding.
Like, what is happening? Okay.
Did you see my face? I was like,
I'm doing the TMZ thing. I'm just trying to.
Oh.
the TMZ of legal tech.
I was
yeah.
following along. Yeah.
Probably the only other person who's actually watched TMZ. I've seen it all. All right. Well, actually, I mean, in other legal tech making national news thing, I haven't really written about this at all, but I think it's been interesting that there's this trial going on this week in San Francisco that's been getting a lot of coverage in the business press. I haven't seen it covered in the legal tech press, even though it involves the founder of Autonomy, which was at one point, Autonomy was not just a legal tech company, but it was a huge player in the legal tech world. It was one of the biggest e-discovery companies, big in corporate governance. and they had acquired. They were the owners of iManage. They had acquired iManage at some point, and then they got sold to Hewlett Packard, and Hewlett Packard bought them for, what was it, $12 billion or $10 billion or something like that, and then very quickly decided that Mike Lynch, the founder of Autonomy and the CEO of Autonomy, had basically fudged the numbers on the company's sales and its valuation, and Hewlett Packard ended up having to write down $8 billion off of that purchase, and there's been all sorts of civil litigation going on for a number of years. I mean, this goes back to 2012 or something when HP acquired Autonomy. But there's been a lot of civil litigation going on, a lot of proceedings in the, what's it called, the Major Fraud Bureau in the UK or something like that. I don't know if they have a small fraud, minor fraud bureau also, but now there's a criminal trial going on in San Francisco, basically alleging that it was against the former CEO and the former, I think, vice president of finance of Autonomy. Mike Lynch is a huge, I think he's a billionaire from a lot of his tech investments, and so it's a really interesting case. And I mean, there's, it's not specifically a legal tech story, but he was a regular at Legal Week and back in the day, and when they were involved in this stuff, and kind of lost track of that.
How long ago was that they were in legal tech?
I don't know when they got rid of their e-discovery. They might even, HP bought them. I think HP bought them in like 2012, and they continued the products. They called it HP Autonomy. They had HP. They had iManage. Then the iManage people went in and bought, because of kind of all this crap that was happening. The iManage original founders of iManage went back and bought it back from HP in 2015. So like the iManage that exists today is almost like a reincarnation of the original management team of iManage that started in 1995.
That's interesting.
Yeah, it's really it's an interesting story. I just interviewed the iManage CEO for my podcast, but it won't be out till not Monday, but a week from Monday, I think. We were talking about some of this stuff.
I didn't know that history.
Yeah, well, that's what's kind of funny is how again, it's like they were almost like the relativity of their time or something in terms of e-discovery. They were huge. They were a major exhibitor in this space. And as a matter of fact, I found a story, Legal Tech, whatever it used to be called, Legal Tech News, Legal Law Technology News, back when Monica ran it. They like swept the
It'll call that
awards.
in some of our systems if you want to know how updated we
Okay,
are.
yeah. Well,
Yeah.
they like Autonomy like swept the awards one year, like in like 2010, they swept the awards for all the e-discovery categories for the best product. So, yeah, they're gone now. All right. I'm sure that got your daughter interested.
I mean, she was nearly threw herself from the carriage to reach for a remote control. So I don't know what's happening in this game that she's watching, but
so actually one other story I'm going to mention just that I did this week. I didn't do that other story, but one I will mention that I did do is about Ai.law. Now, Ai.law was one of the contestants at Startup Alley at ABA Tech Show this year. And basically they are an AI platform for generating litigation documents. They started out kind of working on responses to discovery and answering lawsuits. This year they rolled out a new feature for generating a complaint in a lawsuit. And so I think there have been a couple of other AI applications for generating a complaint, but I thought it actually was kind of cool. I went in and played around with it. It got a couple of interesting features. One is where you can, even before you draft the complaint, there's a sort of a cause of action generator, or I forget what they call it, where you can just type in a fact scenario and type in the jurisdiction you're in, and it will give you a list of potential causes of action that you can plead in a lawsuit. And then you can go in and answer a couple of questions in another form in terms of who are the parties and what court are you in, and uh, based on that cause of action generator, what causes of action do you want to allege? Write up a description of the facts. You can put in dates or whatever if you want. You can make it as specific or not as you want. Click a button and you get a complaint. And I did it. I mean, I was kind of playing around with it, just kind of making up some fact scenarios and whatever. And it did a decent job. It had some kind of funny language, and as we've said a million times on this show, let's hope no lawyer would ever just take what it generated and go file it in a court. But as kind of a first draft generator and something to work with, I thought it did a pretty good job. And then you can just to further play around with it. It's got this. Well, you can also generate an answer automatically. So I put it back in and developed an answer to the complaint that it generated. But it also has this tool where you can evaluate a complaint and evaluate the how strong the claims are in a complaint. And I fed it into that, and it told me like the weaknesses in the complaint it had generated, which was kind of interesting to see. So, kind of a cool tool, and maybe an indication of what we're going to be seeing a lot more of, at least in the litigation area.
Okay, I had another VLEX demo this week, and they actually have a similar feature in terms of drafting complaints and pulling apart complaints and telling you what's wrong with the complaint. But
Do
what
they?
I wanted to ask you about that product is, what is their source of primary law? I mean, I hope they're not using Google. Where are they getting their primary law from? Because that
I
would
don't know.
well,
Well,
that's a
they're
good
not putting
question.
law in. They're not putting law into the complaint. They're putting.
Yeah, but wouldn't, even if you're coming up with things, like defenses, you have to have access to the law to come up with
Right.
defenses.
No,
So,
absolutely. There's some basis for their understanding what causes of action exist in different
right.
jurisdictions and what defenses are to those causes of action. And I don't know the answer to that.
Yeah.
Isn't it mostly just statutory? Oftentimes, I mean, if you're just making allegations,
No, a lot of common law.
Yeah.
well,
A
yeah,
lot of common
I'm
law in a
thinking,
complaint.
I'm thinking more criminal. But yeah, when you're talking about
Tort is
criminal, it's
common
more
law.
common law. Yeah.
Yeah. I did the scenario I did had to do with a libel. I made up a libel case basically of a local businessman being libeled by a online news publication or something like that that accused him of of bribing government officials or something. I made up a quick fact scenario. It did a pretty good job. I mean, again, maybe libel law is pretty standard, and maybe it's not all that. Maybe it's not rocket science for it to kind of put together what the claims would be, but
Well, it can vary from
it
state
did
to
a decent
state with a lot of the claims in a civil matter, for sure. I was getting stuck in I was a co-author for a Thomson Reuters treatise for a decade that was all the substantive elements of crimes in New York. So
Yeah.
I got stuck in that that wheelhouse. But
Right.
yeah, I mean, I think it's super interesting, and it's an interesting application. It reminds me a lot of the contract review software tools, except they're just using it in a litigation context, and it seems super interesting. But it also seems like the kind of thing that doesn't necessarily need to be specific to such a narrow use case. I feel like maybe it wouldn't surprise me if they just started to expand, because it seems like that functionality of reviewing a document, you just have to add new data sets that can review a different type of document and provide a different type of output. Did they mention if they were going to start expanding the use cases into different areas of law? Or
Well, the
different...
guy who started the company is a litigator himself. He is a currently active practicing litigator. So that's probably where his mind is at. He does have some sort of a contract. It has a contract clause generator too, but that seems like something they just tacked on because they realized they could. But it's mostly focused on litigation. It's answering discovery requests, responding to complaints, generating complaints, can summarize medical records and answer questions about medical records. That's another interesting area. I've seen a couple of tools now that are doing that, where you can just kind of feed in voluminous medical records and just start asking questions. What was the initial diagnosis by the first doctor to look at the patient, or on what date did this or that treatment happen or something, and just quickly get answers out of medical records. I haven't tested how well theirs does on that, but I've seen some others that are really effective at that.
But so here's a question though. So I'm posing it to the panel and anyone in the comments as well. Do you think that the future of AI in legal is all these specific use cases where it's very targeted towards a specific practice area or a specific type of one particular aspect of litigation, not like litigation analytics, but just the pleadings and the response, the procedural aspects of it? Or do you think it's going to be a broader, like, where it's going to, where as the AI develops, it can, and is trained, and then we sort of almost get beyond the training because the AIs are no longer even going to need to be trained. They're going to train each other. I don't know exactly how that's going to work, but are we not going to, is the general use case going to be more where the future is going versus these very specific areas? And are they going to get outdated or outmoded, become no longer useful after pretty quickly when they're so specific in their use case? What do you guys think? And so the short question is, I always go in circles. Specific use case or general use case? Like, where are we going in legal? I should have opened with that.
I don't know. Have you ever met a tax lawyer? I don't think there are any generic tax answers. I mean, tax, that just seems to be one area where there's so much that is very specific to that practice area. And that's not the only one. I mean, compliance issues, regulatory compliance is really specific and complex. So I don't know. I mean, even litigation is very broad, even though it's a specific kind of practice. I don't know. I think they're going to have to be use related, but I could be wrong.
I mean, they're advancing so quickly. That's what makes me wonder if it's going to get to a point where they've just trained on such a vast amount of data and the processing power is faster and everything, that they can just ultimately be like your legal assistant and everything, no matter what your practice area is. Like a firm just uses one AI that answers all the questions, no matter what their practice areas are. Do you think we're going to get there or no? Anytime soon?
I don't know if this is a good place to segue, but I feel like that. No. But for a reason. I hear your point, but I also see Gene had a story about how GPTs behavior is changing over time, and things are getting dumber. And so that, I think, is a good segue to, will firms all get one AI that fixes everything? No, because it gets dumber.
Or what it began to remind me of when I read that story, although it actually is more dated than I realized. They did the study back in 2023. But you know what it reminded me of? That that movie, and now I'm forgetting the movie, with the comedian. Oh my God, my brain cells are dying. But it's like the guy comes up with the medicine. It's based on Oliver Sacks. And all of these patients wake up and they get real smart, but it doesn't last. And I wonder if Chat GPT can only be smart for 6 months and then it's just going to revert.
And it's not even,
that was the movie called Awakenings.
Yeah, and it's not even just the Chat GPT generative stuff. Like, I don't know. I have an Alexa, and I am fairly confident that it's dumber now than it was a few years ago. Like, I ask it to play a playlist, like the same one that I've asked it to play for years, and now it's like, do you mean XYZ? And I was like, no. If I meant that, I would have said that. What is wrong with you? And I don't know what it is that's causing these problems, where it's getting more nuanced information and trying to manufacture nuance where it doesn't need to be, or whatever it is. But I saw that, and I saw Niki's question, and I think that they go together, because I worry that the more somebody tries to get reliant on a technology that does this sort of thing, the more likely it's going to have these sorts of problems. And that's why I think no matter what the advantages of this tech is, the blockade is always going to be that at a certain point, until we figure out how to make its attempt to learn not be it's successfully unlearning. If that makes any sense.
Well, I just read about the issue with the product you just mentioned, which I won't say out loud because it'll activate mine behind me, is that...
See, I don't have one in the room, so I'm good.
From what I understand, though, is, and I recall this happening, like they laid off. They could never figure out how to make it profitable other than just selling them. Like they couldn't get people to buy more stuff from them or to use them in ways that would increase the profit margin. And so they just laid off half the staff and know that they're no longer developing it, and that's why it's getting dumb, because they're running on like a skeleton crew. That's what I understand the case to be with that. But I totally agree. Like the underlying issue with LLMs and Gen AI in particular is that they don't understand how it works, and that article alluded to that, and they don't understand why they're having a hard time following conversations. Like now it doesn't remember what you asked it to do 2 questions beforehand, you know, and it is getting increasingly dumber, and it reverts to generic answers really rapidly. So it is interesting, and it's unclear whether it's because they're trying to make things more profitable on the back end by reducing processing power, or else there's too many people using Chat GPT Plus now, and it costs too much to allow that number of deep queries go into it, or whatever the case may be. It's too many tokens. I don't know. But I do think that a lot of it has to do with, again, capitalism trying to make these things profitable, and then they turn things down on the back end. It's like a form of shrinkflation, just in terms of processing power happening on the back end sometimes. So
Also, did any of you find that Google was trying to force you to their Gemini or something about a week ago? It wouldn't let me on my phone. It wouldn't let me do a regular Google search, and I was getting these atrocious Gemini answers.
Yeah.
You can turn it on and off. I've got it on mine. Yeah.
No, it
Gemini
was
is better
coming.
than Chat GPT, I think, but right now.
Well, it wasn't able to answer my questions about, like the hours of a store near me. It was like, that's
Yeah.
not what I need.
Well,
Also,
maybe for a less controversial topic, we should turn to your poll on whether generative AI, Nikki, will end the billable hour.
Stephanie, were you going to say something? I think I talked over you. I don't know if you had something to
Oh
add.
no, I was just going to make fun of Joe. It's fine. We can move on.
Okay. Sorry.
Oh,
It's
wait a
hard
minute. You
on
make
Zoom.
fun
I
of
like
Joe?
to
Yeah, you can do that.
all right. So I last week on LinkedIn, I created a poll, and then this week I followed up on the results of that poll. And the poll was about let me put that in. It was, so what I wanted to know, it's something we talk about here, and that, oh wow, that's quite the link, but I think it'll take you to it. The poll was about whether generative AI would dramatically impact the billable hour or undercut the billable hour within 5 years. I tried to create a reasonable question, so I gave a kind of a long span there. And the original post generated a ton of comments and a lot of really insightful ideas, and people going back and forth, and a lot of good discussion. And so then I just followed up on it this week, and in terms of the results and what everybody had to say. And so ultimately I'll just read off the results to you. So the question was, do you think that what is generative AI will it significantly disrupt the billable hour within 5 years? And 49% said yes, 17% said no, and then 33% said it depends, said the lawyer, because that was the choice I gave them. So I thought it was interesting. There were about, I can't remember, 70, I'd have to go back, 75 votes. So, it was a decent number of votes, and there's a lot of input, and I just thought it was sort of an interesting snapshot of where people are sitting right now in terms of the impact that it might have on the billable hour. And I think it's a really important and interesting discussion to have and to track, because I think for the first time, there's truly potential for that to actually happen. I don't know what it'll look like on the other side if it gets disrupted, but I think it's interesting.
I don't think I just don't think firms are anxious for obvious reasons. It's going to be really disruptive. Although, I think if you go back and look at some of the surveys about fixed fees, I think the proportion of fixed fees has been gradually growing. But I guess the question is there going to be a hockey stick where all of a sudden it shifts and the largest proportion of work is fixed fee as opposed to billable?
Yeah, somebody in the comments said something similar to what you said. They said there's a correlation because there has been an increase in fixed fees, but it's not the cause. They don't think it's the causation. It's not the reason that it's happening, and that it's not going to be the reason. It's just going to be this continuation of what's already happening. So someone else suggested that as well.
And the other thing is, I mean, I think the really disruptive thing is if in-house counsel are doing it, can do a lot of work themselves, that is going to have, I think, the biggest impact on the legal market. So it may be an indirect consequence of in-house counsel being able to do things on their own, and law firms react to that by promising fixed fees. But God knows what the collateral damage inside law firms will be from doing that, you know.
Someone else said that as well. So you're throwing out a
Oh my
bunch.
God.
That was a really good, like, you're throwing out some of the most insightful comments I thought that came from that thread. There were probably like 40 different people that commented on the two. So there are a lot of ideas getting tossed around, but that was one of the ones that I thought was the most insightful, was the idea in that specific context that when in-house counsel, or what the person suggested was in-house counsel would use Gen AI to come up with a draft and then say, here, fix it and make it better.
Yeah.
Like they cut down on a lot of that initial work and then handed it off for the I like to say outhouse counsel. I can't help it, for them to like fix it. So I don't know.
Well, yeah.
But I think that's an interesting, the concept you just discussed, but also that idea of the specific way that this person suggested it might happen is an interesting theory or hypothesis about how it might impact the billable hour, at least in the context of corporate counsel.
This also came up at College of Law Practice Management last week. I wasn't on last Friday, so I didn't get to talk about it. But so we were talking, like a third of the conference is talking about like AI's impact on the practice of law, and obviously like billable hours came up, and it's not just in terms of the billing models. If it's really going to change at law firms, a lot of people were saying it also has to change in the compensation structure, because even at firms where you might have an alternate fee arrangement with your clients, on the back end, associates are still billing the hours that they're working in order to meet their bonus targets and meet their whatever. So even if they're not billing the client that way, they're recording them in order to get their compensation. So even if it's sort of half dying, it's not fully dying. The whole business side of the law firm is still functioning on it. So you still have to change more than just a fee arrangement to really kill the billable hour or really dent it in any way. Like, I don't think anything will kill a billable hour. Like, it's like a cockroach. I think AI has more power to like wound it than anything else has. But it's more than just fee arrangements. I think it's a much broader web. It's ingrained so much, because even when firms are pricing their fixed fees, they're doing the math based on billable hour math. Like, it's so much deeper.
Well, that's a super interesting, what you just suggested about having to structure, you'd have to change the structure of the way that law firms compensate,
Yeah.
the employees. And along the same lines, there's also been some stuff that people have been writing about law schools, and how some law schools are taking a look at what training lawyers is gonna start looking like if you don't have law firms willing to hire brand new lawyers in and train them, because they're starting to think AI is going to replace those initial job functions. So I wonder, I think on a bigger scale, whether generative AI and the efficiencies that it brings are going to force this broad scale change in terms of law schools and how law schools are structured, and entry-level law jobs and how they're structured, and then actually like compensation on the back end, and what does that look like, and how do you determine who's working the hardest, whatever that means, and apply bonuses appropriately based upon that.
Because like I was talking to somebody once, it was last year, even when all this AI stuff was starting, it was somebody who was like no longer at a firm, earlier in their career at a firm. They were early on the innovation scene and was like up and comer, like, look at all this cool stuff we can do with technology, got all excited. And their firm was like, well, great, but where do you plan to get all your billable hours from? And they were like, oh, so you're telling me I shouldn't suggest innovation to the firm? Noted. Surprisingly, that person doesn't work at a firm anymore.
That's when we bring in the 3-day work week.
Yeah.
What's that saying about we always overestimate the short-term impact of technology and underestimate the long-term impact of technology? And I think that's probably true with the billable hour. I mean, I don't know that a whole lot is going to change in the next 5 years. We've been, again, I've been hearing people talk about changing the billable hour for as long as I've been practicing, and that's a whole long time. But I do think it does seem to be inevitable that it has to change in the face of this technology. But it, I was thinking earlier today about the fact that we are in March of 2024. It's just been a year. It was a year ago that Case Text came out with co-counsel. It was a year ago that GPT passed the bar exam. That the New York Times was saying, is this the end of lawyers? There was the whoever study that came out that said that 45% of legal jobs are going to be eliminated
Goldman
through
Sachs, yeah.
yeah, Goldman Sachs, generative AI. And, a year later, it really hasn't been a whole lot of change. There's been some cool products that have come out, like things that can generate complaints for you. But overall, it's been more of a sort of a wow factor than any really significant impact, I think, so far on the legal profession. But we're early in this, and I do think that farther down the road, we are going to see a significant impact, both in terms of the kinds of technologies how the technologies are changing how we practice, and in the impact on things like business models and billable hours.
I don't know. I mean, and I guess I also wonder whether it couldn't trigger legal collateral AI type of jobs, that may be the growth area where just building and testing algorithms becomes part of the legal function, but it doesn't happen inside of law firms because it's going to take a lot of work, because I've been having a lot of conversations with peers about validating results from generative AI. And is every firm going to test every algorithm? It's almost like there needs to be, and I think we're coming full circle, there needs to be a standards organization that validates a different AI products or different AI outcomes. And I don't know whether that goes down to the prompt level, or I don't understand enough about it, how you go about doing that, but it does seem to me that lawyers, in order to validate AI for legal, it's gonna take a lot of people to figure this all out.
Well, that's interesting. When I was talking to Deckert, when they showed me all their Deckert Mind tools, they told me, I didn't know about it. They have this Deckert Innovation Incubator, I'm getting the name wrong, program where they do give billable credit for like testing AI tools. And it might just be like 10 hours here or there, but they got a total of 4,000 billable hours out of it, and invaluable to them of the amount of testing they got of programs and things. And Oric gives credit and Reed Smith gives credit. Those are the three that I know of. And it might not be a huge sum for any given attorney, but it's like 6,000 hours total for the firm. And it's like invaluable in that lump sum of thing. But if someone took, 2 hours one day to do a thing, they didn't have to worry about it going away from a project. They got billable credit for it. So, I mean, it's really interesting.
Yeah, but just think of how many individual generative AI products are going to be in law firms, and how many people can you devote? Is it something that should be done outside just the way, say, there's an organization that tests for security, and they will give a certification. Is there going to be a certification organization for generative AI that has legal specific, people who are trained in law to be part of that process of certifying? I don't know.
I know how much
Maybe
does it
law
pay?
firms should be hiring
I'll
people
do
who've
it.
been trained in legal information and library science
Yeah.
to help do this kind of thing on a high-paid consulting basis.
Right, absolutely. And I also noticed, I don't know if you all saw this, but Harvey has been on a recruiting tear. They had a lot of research related, just what you're saying, research related jobs posted recently, and we were all commenting on, I don't think they were actually even an exhibitor at Legal Tech, and yet now they seem to be coming back like gangbusters somehow.
They're never an
Yeah.
exhibitor anywhere. I mean, they're like they're like non-existent in the usual spheres that everyone else shows up at.
I
Yeah.
think they're pretend. They're like a pretend, it's a fake organization.
They're like Harvey the Rabbit, like the
The salaries were really high, Nikki. You should look at the jobs.
Yeah, no, who's
That's
that?
your
Horace.
investigative reporting,
But
Nikki.
to answer Horace's question, we have not seen the latest Harvey tech because they won't talk to us.
What if that's a PR pitch too? Let's just put a bunch of job listings out there with really high
Then we can get
salary.
investors.
Not
Yeah.
hire anybody. Just make it look like we're hiring. I'm not suggesting they're doing that. I'm just joking. I don't know enough about this company at all. But
I saw Harvey over a year ago and I haven't seen, they haven't let me see it since then. I had access for a while and I haven't seen it since then. And I've written to them a couple times. They don't even answer me anymore.
They have never once answered a single request of message in any medium from any one of our team.
Yeah,
I
we'll
would
try
love to see
courthouse.
their text.
They just did, who was it? Bloomberg, who just had an interview
Yeah.
with them. Yeah. But all right, we are out of time.
And I want to point out my electrician never showed up.
That's why it's so dark in your house. Is that why? Looks dark.
All
well,
part of the
hopefully-
conspiracy theories we were talking about off air.
Right, right.
Exactly. All right. Well, I appreciate everybody showing up and all the people in the audience today contributing. And we will be back next week, I guess, right? No reason we won't be back next week. And,
It's Good Friday. I probably won't be here.
It'll be a better Friday if you're with us.
Oh, no, I thought you were doing the reverse. Have a great weekend.
All right. Have a good weekend, everybody. See you next week.
Bye, all.